very much. Good morning and welcome to the Supreme Court. We have two matters on today's calendar: Tillman versus Shelton Planning and Zoning and State versus Bermudez. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Justice Daria will be our timekeeper. He'll let you know when we have, I believe it's 5 minutes, 3 minutes, and your time is up. How we do these is because we're doing it virtual. The justice that wishes to ask a question will either raise their hand or raise their virtual hand. At that point, please stop your argument and I will call on the justice so that they may ask their question. Are there any questions?
No, Your Honor.
Thank you very much. So the first case is Tillman versus Shelton Planning and Zoning. Counsel, please identify yourself for the record and let me know how much time you wish to reserve, if any, for rebuttal.
May it please the court, my name is Joel Green. I appear before the court on behalf of the plaintiffs, John Tillman and Judith Tillman. The plaintiffs would like to reserve 10 minutes for rebuttal, Your Honor.
Thank you very much, counsel. You have your 10 minutes whenever you're ready.
As I indicated, it's an honor to appear before the court this morning, although I could never, when we began this appeal process, I could never have imagined that we would appear in this format, and you'll forgive me because I know you may have gotten more used to it day to day, but this is very strange for me and not coming to Hartford, but so I'll press on. So we have raised 3 issues in this appeal as the basis upon which we ask this court to sustain our appeal and reverse the decision of the trial court. The first is that the powers of a zoning commission that acts pursuant to the general enabling legislation contained in Chapter 124 does not include the power to adopt planned development districts, which I will refer to as PDDs in my argument this morning. The second issue is that even if a PDD, even if that construct is per se not invalid, we would suggest, the plaintiffs would argue, that the PDD that was adopted in this case fails to create uniform standards for all property in the zone consisting of this single property, and that the regulations are not uniform within on this property and within this zone. And our third argument is that the decision results in an unlawful subdivision in violation of the zoning and subdivision regulations and the statutes. As this court is aware, municipalities exercise zoning power either by adopting the provisions of Chapter 124 or by special act. So 2 bodies of law and legislation have arisen in Connecticut.
Counsel, there's a question from Justice McDonald. I'm sorry, from Justice Mullins. Let me get this straight. From Justice Keller, then Justice Mullins. Very sorry, counsel. Justice Mullins.
Good morning. Good morning. Justice Mullins going first or me?
You, Justice Keller. I'll get it straight soon.
Okay. All right. Good morning, Attorney Green. Can I just quickly ask, because I didn't see it in anybody's brief, how are your clients aggrieved? Are they neighboring residents or?
They are the owners of a abutting property that directly abuts the property that's the subject of the PDD.
And isn't this sort of a preliminary approval, and wouldn't a subdivision application come later when they decided they're going to sell certain areas of the PDD for apartment purposes or retail purposes or restaurant purposes?
The answer to that is, first of all, that looking at the approval, and I urge the court to review the appendix, and in particular appendix part 1, page 140, which is the notice of approval, and specifically the approval indicates that the commission adopted and approved the statement of uses and standards. And the statement of uses and standards specifically say that the parcel shall be able to be subdivided to create separate ownership of the proposed use areas. But going one step further, the definition of subdivision does not require the sale, does not require the actual sale or development. It specifically refers to the division of land into 3 or more parcels, and it specifically says, for the purpose, whether immediate or in the future, of the sale or building development, expressly excluding development for municipal conservation. So it goes on. But the fact of the matter is, the way that the commission acted in this instance is that plan, the statement of uses and standards, was specifically approved as part of the resolution. And at that moment, that zone change took effect. And once again, on Appendix 140, it says that on April 14th, 2017, this zone is effective. And it had a plan of development in it. It had a site plan, and the commission, and it specifically contemplated uses, and it specifically contemplated, once again,
but are the parcels in it definitely delineated permanently, or do they have to take a later step to actually create a subdivision plan and file a map with the town, which is the normal way that you start applying for subdivision approval?
Well, our position would be that in this instance, because of the way that this was structured, a map was filed. A map was filed with the commission, and that map was specifically adopted and approved by the commission. And it's interesting because I understand that this is our third argument and there's not a lot of law on this, but the plain wording of the statute does contemplate the filing of a map and the approval of a map. And in this instance, the map was approved, and there is a specific finding that by the commission that standard, that map, is approved.
Does it make a difference that they call them parcels and not lots?
I think that is, they show divided parcels of land, and they specifically say that these parcels in the plan, it says they may be sold. Therefore, they are plots, and it specifically says, it says the parcels shall be able to be subdivided to create separate ownership of the proposed use areas, and they may be sold in the plan.
All right, thank you.
Thank you, Counsel. Justice Mullins.
Thank you, Chief. I just had a clarifying question, maybe on another issue, but something you just said in response to Justice Keller makes me wonder, is there a difference between a lot and a parcel? Because the statute talks about lots being divided, right? Not parcels.
I would suggest that I want to say that a parcel and a lot are the same thing. And I think that the finding by the commission in approving this division, and by the way, I think the commission implicitly recognizes that it's a lot, because the parcel actually has, and I'm going to bleed into separate arguments here, but in this case, the specific plan that was approved contemplates different uses. For example, as you know from reading our briefs and looking at the record in this case, parcels A and parcel B were each designed for retail use, and the commission actually says parcel E will be used for residential purposes, and there's a description of the number of units and the height of the structure. So by definition, they're creating lots with different uses on them. And that this goes to my second argument on the basis that, which really argues about the notion that the parcels, the uses in the zone are not uniform. Therefore, different parcels are being treated, or different lots and saleable lots are being zoned and have different uses. Therefore, they are not uniform, which runs afoul.
Well, let me just put a finer point on it. Are you aware of any law or any cases that equate a parcel to a lot? or just it just makes sense logically? It makes sense to you, but have we ever said that, or has anyone ever said a lot is a parcel? Same thing.
I'm not aware. I cannot say I am aware of law on that. No.
Okay.
However, the subdivision regulation, specifically 8-18 says subdivision means the division of a tract or parcel of land, and it doesn't say lot.
Okay. My other question for you is floating zone. Do you agree or you disagree that under 8-2, a municipality can create a floating zone?
Yes. I agree that a floating zone may be created.
And maybe let me just see, my real question is, if a floating zone is permitted under 8-2 and it's broad enough to do that, what's the real reason a PDD couldn't be created in the same way under the same authority?
Because with a floating zone, a zoning commission exercises a legislative function to presumably address a need in the community. Floating zone, while it admittedly may land on a single parcel, a floating zone legislatively, when it is created, establishes standards that are uniform throughout the district. And so legislatively, standards are created. The floating zone is applicable throughout the district. And if it is properly formed and conceived, it's not designed necessarily for a single parcel, but is addressed to meet a parcel, to meet a need in the zone, and it may apply to any land in the zone. For example, if there is a particular need, and for example, we have if the need was established in a community and a certain lot size is established upon which a floating zone may be created, then theoretically all property owners and all properties are being treated equally. And while certain parcels may not meet the size requirement, presumably an assemblage could be put together, and hopefully a zoning commission in adopting a floating zone establishes realistic standards which enable a floating zone to truly apply to parcels throughout the zoning district, as opposed to, in this case, a PDD, where in sort of a backwards way, you're legislating a single parcel and identifying the parcel and then creating standards for that single parcel. That's how I distinguish that.
Okay, thank you.
I think I saw another question.
Yes, Counsel. Justice Khan.
Thank you, Chief. Counsel, I have two questions for you, so I'm going to ask the first question. I noticed that on page 14 of your brief, you talk about that the application, even if a PDD is allowed, the application here, that section 8-2 establishes different standards and a requirement of uniformity. But you list that uniformity as intra-district uniformity. Isn't the uniformity really that when you're talking about a planned development district, as far as the standards for residential, they have to be uniform with other residential areas in a town, so that it's intra-district, meaning within a particular type of zone. So a planned development district could include different types of zoning, retail, housing, and that there has to be uniformity within the town as far as when there are within the different areas of.
So in there,
intra meaning.
I do. And here and that goes really central to 2 points of the plaintiff's argument. First is that 8-2 requires that regulations be uniform throughout a district, a zoning district, and adopted pursuant to a comprehensive plan. And a comprehensive plan, obviously, the word comprehensive refers to all-inclusive, broad, complete, far-reaching, this notion of comprehensive zoning. Whereas, so there's this notion of uniformity throughout, for example, a residence AA district in Fairfield, this notion that the regulations apply equally on an intra-district basis, and that is on an intra-district basis. But when you're taking a single parcel and creating a zoning district, and whereas in this case, the Shelton Plan and Zoning Commission adopted this plan of development that said, we recognize that this parcel, this zone was going to be divided, this property is going to be divided into 7 parcels. Parcels A and B are going to be used for retail. And as you could see in the appendix, they got into very, very minute detail as to what could be approved in terms of retail uses in parcels A and B. On parcels C and D, they didn't even act on parcels C and D ultimately and adopt a use. And then on parcel E, they said you can have 200 or 345 residential units. So by adopting that plan intra-district on this PDD, which is one of 87 in the town of Shelton, this is PDD number 87, on this single property, 121 acre property, there are uses on parcel E that you can't put on parcels A and B. It is not uniform in that on that 121 acre PDD. That's right. Intra-district. There's a failure of intra-district uniformity. Properties are treated differently.
I think Justice Doria was holding up a 3-minute, a 5-minute sign. I have just one more question. I noticed that Justice.
You had a second question?
I do, and I noticed Justice McDonald has his hand up, so I'll make it quick. On page 21 of your brief, you talk about that even if allowed, the PDD creates insufficiently clear standards. But I then turn to your appendix at page 830, which is the trial court's decision in this case. And the trial court in footnote 9, which is extensive, talks about the permitted uses for this PDD and goes into great detail about the maximum stories for office space, commercial, residential. Wasn't really the approval of this PDD, and as laid out in the trial court's opinion at footnote 9 on 830 to 833 of your appendix, really lay out how specific the requirements were, and within a particular type of use, whether it's commercial, residential, or office space, that it's very specific.
Well,
how does your argument that they're unclear standards jive with the court's opinion at footnote 9?
Well, there were standards that apply throughout the district. There were certain standards, but the point is there are uses. And while I understand the court enumerated many of those uses, many of those uses did not apply uniformly to, and once again, I'm pointing out parcels A and B versus parcel E. Parcel C and D had no standards. And so it is our position that they were lacking uniform standards throughout. And I understand there were specific standards that the commission in a 24-page resolution did go through for certain of the districts, but they were not uniform.
Thank you, counsel. I'm going to yield the time for my colleagues and back to the chief.
Justice McDonald.
Counsel, this may be a record question, but as I understand it, the zone here was largely light industrial park and a small area of R1 residential, right?
Yes.
Was there ever a zoning map change to change this to a PDD? Or is it still within an R1 and LIP zone?
As I understand it, it is a zone map change to make this a PDD number 87. And the zoning regulations contain if you look at the zoning regulations, they contain standards for the dozens and dozens of PDDs in Shelton.
Well, and that was my next question. Are all of the PDDs uniform in their criteria?
No, they're not.
I assume that was going to be the answer. So what would have happened had this applicant come in first and applied for a zone change to mixed use development? Could that have been done and gotten to the same place?
The answer is no. Well, I haven't looked at, the answer is I have not looked at that question and reviewed the actual sections of the Shelton zoning regulations, but my impression, I will go out on a limb and say no. I don't think, I think the point was there are not zoning regulations which enable the applicant to achieve that goal, the goal of this particular development.
Well, I mean, why not? I've seen people ask for zone changes as part of a precursor to an application before. Is there something that you know of that would preclude that?
I just don't know that the Shelton zoning regulations, in this case, the zone created standards that enabled the that allowed for this particular development with this mix of retail and residential and so forth. And I don't know that there's zoning regulations. There are not standards in the zoning regulations which would accommodate a development like this.
And you certainly know the Shelton zoning regulations better than I do. But if there is a existing mixed use development zone within Shelton with all of those standards, why couldn't the commission simply redesignate some area of the town? Maybe just this 121 acres, maybe they do 125 acres and bring in some of the neighboring areas, but they make that a new zone for mixed use development. Why can't that happen?
Or they create a zone or they create a larger zone. Yeah, that, it seems to me that could happen.
Okay, so okay, thank you very much.
I see that my time is.
Yes, your time in your main argument is up.
Thank you.
Unless you want to use some of your remaining time.
No, I'll wait for a rebuttal. Thank you.
Thank you very much, Council. Appreciate that. As I understand it, the appellees have agreed on how they're going to divide the time up. Is that correct?
Yes, Your Honor. That is correct. Attorney Dominic Thomas for the appellee Shelter Ridge Associates, LLC. We have agreed that I will take 20 minutes and the City of Shelton Planning and Zoning Commission, represented by Attorney Theodosia, will take the remaining 10.
Thank you, Counsel. Justice Daria will make sure that you have your 20 and Mr. Cole will have his 10. Whenever you're ready.
Thank you very much, Your Honor. And thank you, everybody, for the opportunity to argue before such an honorable court. I will begin at the end, so to speak, with the last question. The fact of the matter is, as far as familiarity with PDDs in Shelton, there are actually now close to 99, and I have been counsel on about a third of them. So I am very familiar with PDDs, and I have drafted PDD regulations. The question
Counsel, before you go, there are two justices that wish to ask questions. The first is Justice Keller and then Justice McDonald.
Thank you, Chief. Good morning, Attorney Cole. 99 of these in a single town, is that usual around the state? Are other towns doing these, approving these at that level?
Not at that level.
Yeah.
You have to understand that Shelton began them long before Campion, and that has been very effective. It's obviously one of the reasons why the economic development in the town is so good and the tax base so low. So they have done it after Campion in 2006, and based on the decision of your court in Campion, they made some changes, and effectively, and this was what I was going to respond to, the zone change. It is a zone map and text change. The zone text is the statement of uses and standards. The zone map lays the PDD. Section 34 is the vehicle that you would use to propose the mixed development that Justice McDonald referred to. So in fact, rather than take one of the zones like the CB or downtown zones that they have, they prefer that, following actually the decision that Judge Borden wrote in Campion, the flexibility, and it's allowed them to be very flexible, to then within the standards in Section 34, which is found at page A208 to A218 of the appendix of the appellants. If you read there are substantial standards. The size of the property in different locations. You can't assemble properties, as I have done, or you can have a single piece. And then it sets out strict standards with respect to utilities and everything of that nature. So in effect, they have done that. They can be very small, from a downtown apartment complex and something, to very large. This is the largest, to properties surrounding them that have mixed retail uses and everything. And this way, they get greater control, rather than put all these uses in a single zone, which would be over parcels they don't think are appropriate. So that's been their philosophy over the years. And there are many other towns since Campion that have adopted them.
I thought there was some kind of overall plan where these PDDs are supposed to go in the town. That's not true?
That's in the regulation. It prohibits them in residential areas now. They were used pre-2006 in some residential areas in place of what they called PRDs, Planned Residential Districts. But since 2006 and the change that they made after Campion, they are restricted only to areas that are not solely residential districts. And the commission has designated in the past special development areas, which is mainly along Bridgeport Avenue, downtown, and along River Road, which is Route 110.
All right, thank you.
Thank you. Justice McDonald.
Thank you, Chief. Counsel, I am assuming that the 99 PDDs in Shelton are not all uniform in their requirements. So it's not like there's a PDD zone. It's particularized to each of the 99 lots, right?
Correct. The uniformity is that they all have to comply with Section 34 requirements, depending on where they're located. So they have to comply with size and everything like that. Given
the numerosity of PDDs in Shelton, what is the difference between a PDD in Shelton and spot zoning in Shelton?
Well, first of all, I think the Campion resolved the issue of spot zoning, that it's not spot zoning. Basically, the reason it's not spot zoning is they have designated areas in the city of Shelton for these PDDs to go. They have put some restrictions on it, and they have put some standards. And as it says in the regulation, it's to accommodate uses and combinations of uses that would not appropriately be put in an entire Euclidean zone, which also follows the language in Campion very carefully. And I think the quote in Campion, when it talks about zoning flexibility, and especially when you get in areas in a town that have been developed to a great extent, you don't necessarily want to put uses or combination of uses and allow it to go anywhere. And the best example I can give you actually isn't in Shelton, but it's a project that I was doing for a very large continuing retirement community. And I drafted a PDD type reg, and they preferred that it be put into a certain zone, industrial campus. And when it was presented, actually, one of the commission members said to me, Attorney Thomas, why can't you draft a reg that would allow us to just do one, rather than put this into the industrial campus where we can end off with multiple applications? And so that is one of the philosophies behind it, which is, I think, a very valid planning and zoning tool.
Let me ask the question in a slightly different way then, because I'm not certain I understood your answer in the context of my question. What is this distinguishing feature between a PDD and spot zoning?
The distinguishing feature, I believe, is the standards and the process for which it goes through that they have established with respect to the uses and the integration with the town plan of conservation and development, which is an advisory document. I suppose, as the court in Campion ruled, you know what I mean? There's the allegation of spot zoning, but it is not to prove spot zoning. You can show, as we did, we argued the case of Gaeta before the appellate court, where it was intended, we're going to spot zone this solely for a reason unrelated to planning. The reasons for this zoning are related to planning and land use within the town. Okay, certainly somebody could go in for a PDD and there could be certain factors which might indicate that this is more, rather than a legitimate exercise of zoning authority to change the zone, it's actually showing favoritism or showing disfavoritism to a specific parcel.
So you're familiar with the rule of statutory construction that the particular controls over the general, right?
Yes, Your Honor.
So when we look at 8-2M, which everybody appears to agree is specific to New Haven, 8-2M specifically allows for planned development districts in New Haven, but there is no similar planned development district language in 8-2. Why would we not say that the legislature made a conscious effort that for whatever reason that they were going to allow planned development districts in New Haven, but in no other area of the state? Why is that not correct?
As Judge Dominowski pointed out, and I think he very well answered the question in his memorandum of decision, Senator Looney, immediately after the appellate court ruled in Campion and threw out the PDDs, raised a bill and addressed the bill that would allow PDDs in New Haven, since that was a very important part of their land use plan. And that was passed. And he also, I believe, I don't have the page for you, his memorandum of decision, I believe, is at page A16 of the appellant's brief through A38. I don't have the exact page right now, but he dealt with that very clearly and said that it was directed solely to salvage the New Haven PDD after the Campion appellate court thing. And
well, let me put it this way. The amendment didn't amend 8-2. It created a whole new section, which is now codified as 8-2M. That may be, your history may be right, but the language of permitting planned development districts only exists in 8-2M, not in 8-2. So using the rule of statutory construction that we presume the legislature knows what it's doing, and they've allowed for planned development districts in New Haven, but not allowed it in 8-2, why wouldn't that control the outcome of this case?
Because this court has already spoken. And in order to rule that way, this court would have to overrule itself in Campion. The language in Campion, and I believe
Campion came out before 8-2M, right?
Campion came out after 8-2M. Campion Supreme Court came out after 8-2M, I believe. Campion is, as it says, as Judge Dominowski pointed out, 8-2M was in response to the appellate court decision.
Right.
And it's introduced. Whether it passed before or after the decision, I can't give the exact date, but it responds to the appellate court decision, and then the Supreme Court overruled the appellate court.
Right, but my point is that it was just a matter of days, as I recall this record, when our opinion came out, but we never addressed the legislative action taken, which resulted in 8-2M in Campion, did we?
No.
Right. So that statutory framework is sort of is an overlay, if you will, on our holding in Campion, right?
No, I disagree with that.
Why not?
I do not think it's an overlay, because the decision in Campion basically holds that the language of the special act, which is similar to the language, and the court actually said, referred to 8-2, and the language in 8-2 permits floating zones, which permits PDDs. So basically, it was done without any reference at all to 8-M. 8-M was then after the legislature in response to an appellate court decision. The Supreme Court, looking at the basic question of whether or not 8-2 gives the power to a municipality to adopt PDDs, in its very lengthy and well-reasoned decision, said that 8-2 has the power to do it. If 8-2 already has the power to do it, why would the legislature have to redo it again?
Thank you.
Okay, no more. I was just checking. No more hands up. So, and I know that responding to questions takes up. I do want to. I think I've addressed the issue of that. I do want to quickly address the issue of the subdivisions. I would call the attention of the court with respect to the issue of subdivision to A-90. Page A98 of the appendix. Of the appellant, which is the Statement of Uses and Standards. And a PDD, the Statement of Uses and Standards is the zoning regulation that governs that zone change. And with respect to the issue of subdivisions, which was partially quoted by Attorney Green, at page A99 in section 3C of the Statement of Uses and Standards, it states, the parcel shall be able to be subdivided to create separate ownership of the proposed use areas subject to the approval of a subdivision plan, which is something that is done now more often, not just for the transfer of property, but also for financing of property. And in the matter I was before the commission last night, to subdivide it to allow a REIT to include an office building into its portfolio. There was no subdivision. To require a subdivision and to actually effectuate it, as Justice Keller pointed out, you need to have a subdivision Mylar created, signed by the commission, and filed in the town clerk's office. That was not done. No application has been made. As Judge Darmanowski pointed out over and over again, the parcels were development parcels. They were development parcels, as I'm sure you have read it, but the resolution from A116 to A139 of the appellate is a detailed 23-page resolution done by the commission. And it refers to these development parcels, which were set up to address the unique and difficult topography of the site. They were not in any way a subdivision. This leads me right into the issue of standards. The issue of standards and whether or not it's uniform. What I think is very interesting about that the uniformity argument, the person who would be aggrieved by the uniformity argument is the applicant himself. It's the applicant that proposed we are going to have uses in the various development parcels and we are going to have standards in it. It is not a question that there is no requirement. And Campion, the court in Campion clearly addressed the uniformity issue and the standards issue, but you have a development parcel that designates where they are. It is actually more restricted than normal zoning. Because as Judge McDonald said, could you just change the zone? Well, you can change the zone and say you can put these pieces anywhere. In a PDD, the applicant is required not only to ask for uses, but the applicant is required to submit an initial concept plan which shows where the uses are going to go. So it's not a question of uniformity, it's uniformity within the entire zone, and the zone standards say you can put it here. Just like in a regular zone, you can have liquor stores, but many towns say, but you can't have a liquor store within 1,500 feet of a school or something of that nature. So the issue of uniformity, I think, was completely taken care of by the court in Campion. And I do believe, with respect to the issue, Judge of whether or not 8-2 authorizes it, Judge Dominarski said it best, and I'm quoting from pages 25 to 26 of the appellant's appendix, where he said, turning to the plaintiff's argument in the present case, this court concludes that Campion is not limited to its facts. Although Campion and Sheridan interpreted zoning authority derived from special acts, from special acts, not the fact that the language was contained in the special act. The court further concludes that 8-2 authorizes. In other words, it was not the fact that it was a special act. Judge Dominarski says it was the language in the special act, which is similar to the language in 8-2. And that is referred to specifically. So therefore, that also relates back to my response to Justice McDonald, that if the language authorizes floating zones, if floating zones are the same as PDD, the only way for the court to go against that and change it would be to overrule itself in Campion. I do believe that, the fact that not only Shelton, but many other, I'm sorry, the hand is up.
Yes, thank you. Justice McDonald.
Thank you. Well, my understanding is that a floating zone is a zone that just hasn't been, that has uniform requirements that hasn't been landed on a particular area yet. That's very different than what a PDD is. There's no uniformity. It's uniform within itself, but not within all other PDDs. Those are very different. And so I don't want to let you off the hook that they're the same. They're not the same.
Well, first of all, the court, Your Honor, the court in Campion said they were the same and said the differences. I quote the page. I think it's at page A16 of our appendix, which is my brief. I'm quoting from Campion, which is at page 529 to 530 of Campion. And I believe that, I'm sorry, that's the wrong quote. That's the quote on flexibility, which I think is important. There's a quote right before that in Campion in which they said that there are differences between a floating zone and a PDD, but those differences are insignificant. And the fact that they are zones. In a floating zone, you can lay it on a certain area. You can designate the area. You can designate, quote unquote, the spot where you want to put it. You can do that, and as long as it complies with the standards. In a PDD, you can actually, again, you have to comply with all the standards. If you comply with it, you're over the required size, you can put the zone on it, and then you create the standards for that zone when you do it. And the court said there is no difference because you're still choosing where it goes. So the Campion court has already held that floating zones and PDDs are the same and authorized. Thank you very much for the opportunity to argue. I now turn it over to Attorney Theodosia.
Thank you very much, counsel. You may proceed.
Good morning. I would like to address a question of Justice McDonald earlier to my brother counsel. I am the counsel for the City of Shelton, Francis Teodosio. And yes, Your Honor, City of Shelton zoning regulations do allow an applicant to come in, petition for a zone change, and then provide a new application, and it can be done all in one step. It is not something that is barred in Shelton. But the PDD, as my brother counsel, Attorney Thomas, has explained, is a much more restrictive process that we enjoy in Shelton because an applicant comes in, and they have to come in through our Section 34, which does lay out a good deal of regulation, restriction, bulk standards. If I could liken the application process here in Shelton to a coloring book, Justice McDonald had indicated he thought it sounded like spot zoning. In my analogy here, spot zoning would allow you to draw anything on the page. We do not allow that. We essentially have a coloring book, if you will, that has lines, restrictions, regulations, and the applicant comes in and within those lines, restrictions, and regulations can petition to do something, can even petition to create the picture, but the zoning regulations do restrict the discretion both of the commission and the applicant himself. So I think that the process does very well protect the city of Shelton, and I think it's in compliance with Section 8-2 of the zoning regulations. With regard to your question concerning Campion, I agree with Brother Counsel that in the Campion case, the court did equate the PDDs to floating zones. And I think that the process of creating a floating zone, Your Honor, would literally be the same thing as the application here. It would just occur ahead of time. And in creating the floating zone, we wouldn't have the limited restrictions that we have with the PDD. So for all those reasons, I think that the PDDs as they exist in Shelton are compliant with Section 8-2. I echo the claim that Campion allows the PDDs in Shelton, and I would answer any other questions that the court has.
Thank you, Counsel. Justice Keller.
Thank you, Chief.
Thank
Yeah, thank you. Attorney Tedosio, I'm concerned that, you know, there's 99 of these, they're in the town, they're all over the place. I had this vision that, you know, a lot of towns have vacant, unused land along highways and, you know, other major places. But it seems like these, even though you have a plan, it seems like these are going everywhere. So, you know, what are the people in the town who kind of rely on the nature of their neighborhood and the neighborhood they moved into? What are they supposed to do about this? It seems like someone can buy up a couple of parcels of land. Is there any limit on acreage? Does it have to be a really large parcel so that it might be more restricted to the outlying areas of the town? Or can it be just a couple of acres?
There is a limit on the acreage with regard to it. There is a limit with regard to the locations where it can be. And the areas that we are isolating are primarily those areas that are along Bridgeport Avenue, which is a designated area for development in Shelton, and also along the old abandoned Main Street area in Shelton, which at one time had been populated by very large industrial type buildings that have since either burned down or been abandoned. So yes, there are a lot of them in Shelton, but they are designated in specific target areas.
Thank you.
Thank you, Counsel. Justice Secker.
Going back, Counsel, to the perhaps I should be asking this to Attorney Thomas, but I am too late to the buzzer. So I'll ask you. If you can't answer it, that's fine. That's fine. It's on 82M. Would it be correct? I just checked. It looks to me like the statute became effective about 4 days before Campion was issued. Would it be accurate to say that our decision in Campion, read as you read it, renders 82M surplusage and unnecessary, meaningless? Yes. Oh, yeah, okay. I'm just wondering, is there any, I mean, I understand a sort of a realpolitik or, you know, realistic view of the chronology of events here. if we use that for our statutory interpretation, maybe that's a fair reading. The history provided by Judge Dunarski and your brother counsel. But are there any cases, do you know of, or is there any is there any precedent for doing what you're requesting us to do in that respect?
Your Honor, I think that's the reason we're here. I think that we have 8-2M and the court's interpretation in Campion. You have the statute that's been cited by brother counsel, Mr. Green, and we've given our interpretation, Attorney Thomas and myself, and it's for the court to decide.
Thank you.
Anything further, counsel?
I don't have anything else, sir.
Thank you very, very much. Are you ready to proceed, counsel? Mr. Green. Sir, you're muted. Your microphone is muted.
Can you hear me now?
Yes, thank you very much.
I urge the commission, I'm sorry, I was at a zoning hearing last night. I urge the court to look at the zoning regulations and in particular section 34. But the thing is, there's an entire body of zoning regulations for the town, for the city of Shelton. And yet there is this broad area, and it is a broad area in Shelton, which allows PDDs, of which there are 99 PDDs. And I question how anyone can be comfortable with the notion that there are 99 districts with individually on an application by application basis standards adopted. Now, I have to, by way of rebuttal, the standards for establishing a PDD, and I note that the court asked several questions. All that you need is in one district, in one area where PDDs are allowed, all you need is a minimum of 60,000 feet. That's an acre and a quarter. In one area, you only need 10,000 feet. And then finally, in another area, the Route 8 corridor, you only 20,000. It's only minimum lot size. There's no maximum lot size. It's minimum lot size, and that's set forth in 34.3.1 of the zoning regulations. As a standard, the permitted uses, it says permitted uses in any PDD shall be limited to those uses specifically identified as permitted in said PDD. So basically, permitted uses are whatever the commission decides are the permitted uses. That's 34.3.2. Lot coverage says that the buildings and structures shall not exceed 60%. But then the regulation says that the commission may increase such total lot coverage within certain areas as necessary to accomplish the intended purpose. Floor area ratio will not exceed 80%, but the commission may increase it if it chooses. And then there are height restrictions in 34.3.5, but it specifically says that the commission may increase it under certain standards. So it is the position of the plaintiffs that this notion of a plan is basically, it's a plan not to have a plan. I see that as a question.
Counsel, Justice Ecker.
Yes, and I looked briefly. I looked at section 34 before, and I'm looking at it again. But you know it better than I do. There appears to be some limitation as to where in the town of Shelton or city of Shelton the PDDs can be located, but it's not as intelligible to an outsider as it may be to somebody who knows the city. So can you, I don't know if it's in the intent section or where, can you give us a better sense of where within the coloring book that your brother counsel referred to, these are theoretically allowed by regulation?
There's a vast area along Bridgeport Avenue, basically in all of the commercial and industrial areas along Howe Avenue and along the corridor of Bridgeport Avenue. It's basically all of the industrial and commercial areas. And I think it's fair to say that it excludes basically solely residential districts.
Is there any graphic illustration of that in the appendix or not? Just for those of us who could use it.
I don't know that.
Okay, that's fine.
Council, Bridgeport Avenue, that's the road that runs parallel to Route 8, right?
Correct.
Thank you. Justice McDonald?
Thank you, Chief. Council, but this PDD does abut residential properties, right?
Yes.
So taking what I'm hearing you say, taking it to the extreme, if these Planning and Zoning Commission members thought it wise, they could have permitted a PDD that would allow a developer to put a 30-story building on the property if they thought that was wise and would enhance the tax base of the city, regardless of the surrounding residential areas. Is that correct?
Well, the description of the district, as I understand it, includes property that bounds on a residential district. There is a height limitation.
I thought you said they could vary it in their discretion.
Well, it says specifically in the regulation, it says 60 feet shall not exceed a height of 60 feet, provided that the commission may permit a greater height if such building is located within an area which is primarily devoted or zoned for industrial and commercial development, or such height will result in preservation of more open space on the tract. So in establishing the zones, just to go one step further to your question, the PDD, the regulation allows PDDs on properties that specifically bound on residential zones, but not on properties that are exclusively in residential zones. And if I may just follow up on a question that Your Honor asked on my primary case, when you asked about why couldn't they establish a mixed-use development, or is there a regulation for a mixed-use development? And the response is, if there isn't a mixed-use development, then one could be adopted. And the point is that mixed-use development would be available uniformly throughout the district and not just on this particular property. So I think that's an essential point, that yes, if the regulation for a mixed-use development such as this did not exist, then theoretically, in the normal exercise of zoning powers, not with a PD, a commission might adopt a mixed-use development zone. And the point is that it would apply uniformly throughout, say, Commercial District 1, or what designation is.
I won't chew up much of your time, but this is a pretty large parcel of land. They could, if they wanted to, have made that zone coterminous with the 121 acres here, couldn't they?
Yes.
Thank you.
I don't know. So, and just to follow up, 8-2M is a great, and that's a great point in terms of the legislature. If you think about it, all that the legislature had to do, if it had intended to extend PDDs into the development pursuant to Chapter 124, is add about 8 words to Section 8-2. And the legislature declined to do that and instead went to this extraordinary measure of adopting a wholly separate regulation, 8-2M, to allow specifically PDDs. And I think that is an important point. But there are other devices that the legislature enacted over the years that allows the kind of flexibility that we're talking about. In other words, PDDs were theoretically a notion of creating greater flexibility in the zoning process, but the legislature adopted, there were so many measures that had been adopted. For example, there were, and frankly, a lot of this is in Campion, the appellate court decision in Campion, and it refers to special permits and special exceptions. It refers to of the, I see there's a question.
Thank you, Counsel. Justice Khan.
Thank you, Chief, and thank you, Council. It's just a clarification. You were asked about whether there were maps of the area and the site, the entire site, and then the parcels. Are those actually located in your appendix at A106? Is that what the proposed plan was? Because I'm seeing a map that shows, it says vicinity map, and it has a site that's highlighted, and then it looks like what appears to be residential area behind it. And then there are other maps that are specific that appear to be a topography or wetlands map, and then there's a map that indicates which are parcels, where the different parcels are. Parcel A, C, D, open space. So
Yes,
are those maps that were used to indicate what this proposed development plan would be? That's
correct. It's a 121 acre site. That is correct, Your Honor.
Thank you. I just wanted to ask that question. Thank you.
Thank you. So once again, it is I just want to make it, perhaps when you see a city like Shelton, relatively small municipality with 99 PDDs, what the plaintiffs would be of the position that either, first of all, Campion did not specifically reference Chapter 124, or with 99 PDD, maybe it is time to rethink Campion and rethink the applicability of Campion. I want to thank the court for hearing me, and the plaintiffs urge the court to sustain their appeal and to reverse the decision of the trial court. And once again, thank you for your patience and your thoughtful questions.
Thank you very much, counsel. Thanks to all counsels. We really appreciate you doing this. We understand that this is a different format, doing this virtually, but it probably is something that we will keep at least in our pocket from now on into the future, so we can hear cases that normally we couldn't. We appreciate it. We are in recess until the next matter.